Welcome all, and thank you so much for joining this Affirm Opportunity National Affirmative Action Oral Argument Debrief. This debrief is brought to you by the Lawyers Committee for Civil Rights Under Law, LDF, AAJC, and AAPF. My name is Maya Emerson, and I will shepherd you through our event today. We will get started in just a moment. But first, we have a video for you. And secondly, we have a few quick reminders. One is that if you have questions throughout the event, there is a Q&A feature at the bottom of your screen. Drop your questions there, and if we have time, we will get to those during the program. So thank you again for joining us today, and we will get the program started soon.
We're going to teach America something. We're going to teach America something about what matters. We're going to teach America something about who we are, who you are. We're going to teach America that the ideal of colorblindness is nice, but if race matters, when I walk down the street, if the power, the vote, the vitality of Black and brown people and other people of color gets sapped from us at every turn, why shouldn't race matter in college admissions?
I benefit from affirmative action. I got in because of affirmative action, because my race is essential to my identity and my story cannot be told without it.
This is what democracy looks like.
Tell me what democracy looks like.
This is what democracy looks like.
We are the next generation of leaders. We will have our voices heard. Regardless of what happens today, we will not go back. We will continue to fight for our rights and create a more equitable future for all students.
We must believe that we can win, because otherwise, we've already lost.
All right, with that, welcome again, and thank you for joining us. Again, this webinar is brought to you by the Lawyers Committee for Civil Rights Under Law, Asian Americans Advancing Justice, AAJC, the NAACP Legal Defense and Education Fund, LDF, and the African American Policy Forum. My name is Maya Emerson, a team member at the Educational Opportunities Project at the Lawyers Committee for Civil Rights, and we are thrilled that you decided to be in community with us today. So we hope that this will be a space to debrief the facts and process how we're feeling together. So finally, I have a feeling that you logged on today because you understand that after oral argument, our efforts are far from being over. So almost most importantly today, we will discuss the work ahead. So let's get into it. To set the stage for this afternoon and for our gathering, it is my pleasure to introduce to some and present to others the President and Executive Director of the National Lawyers Committee for Civil Rights Under Law, Damon Hewitt.
Thanks so much, Maya, and thanks to colleagues from our sister organizations. We've fought this fight together, not just in these cases, but for a number of years alongside LDF, AAJC, and the African American Policy Forum. Those four organizations, our four organizations, along with the Lawyers Committee for Civil Rights Under Law, are not the only ones in this fight, but we have stuck particularly close together because we bring complementary strategies, skill sets, insights, and perspective. It's what it means to be in coalition and partnership together. And I'm so proud to work alongside you. You know, if there's anything worse than racism, if there's anything, it might be false allegations of so-called reverse racism that are designed to confound, to confuse, and to limit opportunity. That's exactly what's happening in these cases called Students of Fair Admissions versus Harvard and versus UNC. This cynically named group, Students of Fair Admissions, of course, founded and funded by the same person, Ed Blum, who was behind the gutting of the Voting Rights Act and the gutting of protections for voters of color, especially Black voters in states and jurisdictions that had a documented history of racial discrimination. What they're looking for on the surface seems nice, a colorblind society. but they're trying to get there through nefarious means. They're trying to get there by looking for a racist boogeyman that simply does not exist. They failed to prove racial discrimination in these college admissions plans in the district court and the Court of Appeals in the Harvard case, after the court considered every detail of these plans. And they lost because there is simply no discrimination at issue, no illegal discrimination at issue. These plans are holistic admissions plans. They do not constitute racial preferences or any automatic points or demerits based on race. But they're counting on this US Supreme Court that's currently comprised to make a Dobbs play, as in Dobbs versus Jackson Women's Health, the abortion rights case from last term. They're counting on this court to simply change the law just because these litigants don't like it. Now, we know the law hasn't changed since Bakke and Grutter, but what has changed is their tactics, trying to recruit Asian American students to drive a wedge between and among us. And our solidarity in this webinar and in this community of advocates demonstrates that that effort, we believe, has fallen flat. But something has changed since then. What's changed is that we've seen, since these cases were initially filed years ago, efforts to overturn our democracy and the legitimate results of elections, violent white supremacy on the rise, anti-Semitism, neo-Nazis. We've seen the murder of George Floyd by law enforcement and other people of color as well. We've also seen a national uprising, multiracial, intergenerational, interfaith, people peacefully taking to the streets to demand not just justice in the abstract, but racial justice and a new vision, therefore. Now, these litigants, students of fair admissions, they don't have any good answer for what colleges and universities are supposed to do. They don't have an alternate legal standard. They just want to have their way. In fact, as multiple justices said from the bench during Monday's extended oral argument, it seems that these litigants simply do not care about the likely precipitous drop in Black and brown students and even some Asian American students when it comes to college admissions if they are able to upend the legal standard. As Justice Ketanji Brown Jackson said from the bench, and I'll paraphrase a bit, she essentially said that these petitioners are trying to require applicants of color to hide their identities and to also have admissions professionals pretend like they don't see us for who we are. That, we believe, is inherently racist, inherently discriminatory. As Justice Jackson put it, that itself presents a bigger equal protection problem. As one of our student alumni clients, Andrew Brennan, wrote, our colleges and universities are incubators for our democracy. If we want a democracy that is pluralistic, multicultural, and inclusive, then those are the conditions we must cultivate on college campuses. So we gather here today to talk about the arguments that were, the cases that are still pending, but also about the road ahead. Because if there's anything we know, it's that this is not our first rodeo and not our first defense of race-conscious admissions. And it's also not the first or last time that we will have to push these institutions to be fully and truly mission-driven, whether you're an elite private school or whether you are a state flagship public institution. It's important that they widen the aperture of what they consider to be merit, not rely on normative criteria that are proven to underpredict the talent of students of color. And so regardless of what happens in these cases, we know we still have work to do, because if democracy and the promises of democracy are to be real, that is not self-executing. We know we have not gotten this far by faith alone. It's by acts as well. And we know we have to make it happen together. Thanks so much for being with us today. Back to you, Maya.
Thanks so much, Damon. It's hard to follow Damon in speaking. So now you all are in for a real treat. You are about to be privy to a live debrief of oral argument from a powerhouse panel of civil rights litigators and advocates who have been a part of efforts to protect affirmative action for years. So again, if you have questions while our speakers are speaking, please drop them using the Q&A function. If we have time, we will pull audience questions. So let's get into it. I'm so pleased to introduce to you Genzy Bonadiaz-Torres, Associate Director of the Educational Opportunities Project at the Lawyers Committee. Also, Kristen Penner, Senior Research Analyst at the African American Policy Forum. Nia T. Shaw, Director of Litigation at Asian Americans Advancing Justice, and Jen Healy, Director of Strategic Initiatives at the NAACP Legal Defense and Education Fund. Welcome all. Let's get into it. So, Jinsey, let's start with you. Can you briefly catch us up on these cases in terms of the claims involved? What's before the Supreme Court, and logistically, what happens next?
Thanks, Maya. I'm really excited to be here. So my job is to quickly set the stage for the meat of the conversation. And so as Damon stated, when discussing the plaintiff's claims, it's important to recognize at the outset that the plaintiff's attack on race-conscious admissions is not new, but it does draw from a long legacy in this country of challenging the legitimacy of any program that tries to ensure that Black and Brown students have access to a high quality education. It's why we're fighting back, and it's why these cases are critical for protecting the promises of our democracy. But to lay out a basic understanding of the Harvard and UNC lawsuits, the cases were brought on the same day by the same man, Ed Blum, who's backed by an extensive network of well-funded conservative think tanks and funders who want to roll back civil rights gains. While Blum and his organization misleadingly named Students for Fair Admissions ostensibly brought this case on behalf of students, it's critical to note that the plaintiffs completely ignored and erased the actual students and student experiences central to the issues at hand. The plaintiff's case in chief presented absolutely no student testimony and absolutely no student application file indicating discrimination. By contrast, the Lawyers Committee, AAJC, and LDF collectively across the cases presented a multiracial group of former applicants, students, and alumni, along with expert testimony in the UNC case, that uniformly and publicly explain that race and racial diversity matter. It matters for students to share their experiences and perspectives in the application process. It matters for a learning environment where interacting across difference yields deeper understanding and problem solving. And it matters for our society to prepare leaders who can tackle today's most pressing problems that often fracture along the fault lines of race. In this past Monday's argument, the plaintiffs posed two types of questions for the Supreme Court to resolve. First, they've asked the Supreme Court to overturn over 40 years of case law that has consistently said that race-conscious admissions is legal and necessary. This precedent dates back to the 1970s, known as the Bakke decision. And in Bakke, Justice Powell wrote the controlling opinion for the Supreme Court that affirmed that nothing short of our national progress depends on ensuring that colleges can enroll highly qualified students of all racial backgrounds, because that diversity demonstrably enhances learning by increasing cross-cultural understanding, reducing isolation, and developing a pipeline of diverse leaders. The Bakke decision also laid out the parameters of constitutionally permissible programs. And it's important to note that the current case law does not allow for racial quotas or bonus points. Rather, it allows colleges to engage in individualized race-conscious programs that are both highly holistic and humanizing. Programs can consider race as one of many factors in admissions, considering them alongside everything else that is known about the student, and alongside all other forms of diversity, including socioeconomic status, where an applicant grew up, their parents' professions, and a multitude of other factors. It's in this incredibly context-rich process that colleges may consider race. The Supreme Court has since heard a pair of cases in the early 2000s, Grutter and Gratz, that reaffirmed the underpinnings of Bakke, that individualized race-conscious programs are lawful and necessary. And as recently as 2013 and 2016, the Supreme Court reaffirmed these central tenets in the Fisher litigation. And yet, despite the Supreme Court's very recent affirmation, this precedent once again hangs in the balance. So that's the first bucket of questions. The second bucket is that short of a nationwide prohibition on considering race, the plaintiffs have also asked the Supreme Court to find that Harvard and UNC have not complied with this existing precedent. And they've made these claims despite a really robust evidentiary record that demonstrates that such programs closely adhere to Bakke, Grutter, and Fisher. The cases do differ in some of their legal claims and facts. For example, the UNC case does not involve any claims of racial balancing or discrimination against Asian American students, but there are important similarities. In both cases, there were clear and decisive victories in all of the trial courts and the circuit court below. And these courts ruled in favor of race-conscious programs after a very extensive review of the record. In both cases as well, a multi-sector and diverse group of stakeholders filed amici briefs, also known as Friends of the Court briefs, explaining the necessity of racial diversity and race-conscious admissions. These groups range from civil rights partners to the medical sector, to the military, to Fortune 500 companies, and much more. So, turning to some practical matters, while the cases were originally consolidated, they were then separated so that Justice Ketanji Brown Jackson could participate in the UNC case, although she has recused herself from the Harvard case because she was previously on Harvard's board of overseers. As such, the cases had separate arguments and will have separate opinions. On Monday, the court heard around 5 hours of oral argument, and a decision is expected late in their term, around late April or June next year. And that, I hope, is a quick catch up on where we find ourselves. And I'm delighted that we get to build upon this moment with this esteemed group of panelists and those of you who have joined us.
Thanks, Jinzi. We appreciate you laying a solid foundation for all of us for the rest of the conversation. So now I want to turn to Jen and then to you, Kristen. Why do these cases and issues continue to require our attention, even as the immediacy of oral argument fades?
Thank you so much, Maya. And first, I just want to thank Lawyers Committee for putting together this program and just feel so honored to be a part of this very esteemed panel. And I also want to take a moment to congratulate David Hinojosa at Lawyers Committee, who argued on behalf of the interveners in the UNC case and the oral argument yesterday. I think it makes all the difference in the world to have a civil rights lawyer in the Supreme Court arguing about these issues, because this has been something that has been so important in the civil rights community for such a long time. And I'm sure it meant all the world to your Lawyers Committee's clients as well. So congratulations. But to go back to your question, Maya, I mean, well, first of all, as Jenzi said, this issue has come up repeatedly. The court has been very consistent about the permissibility of considering race, in a holistic process as one of many considerations. And yet, conservative activists continue time and time again to try to come back to the court and hope that the case law will change, or that somehow this ability to consider race for the educational benefits of diversity somehow will be undermined. And each time they've gone to the Supreme Court, they have lost. The court has affirmed over and over again. And this happened in a case against University of Michigan, against the University of Texas. Now it's against University of North Carolina, as well as Harvard. I think that, the cases involve access to very competitive, colleges and universities, but the larger picture is more than just about getting into these colleges. It's really about whether or not we as a country, what do we as a country want our society to look like in terms of the people who have access to incredible academic resources like the University of North Carolina and Harvard, which is a pipeline and a pathway to leadership positions, whether it's in corporate America, whether it's in government, whether it's, in so many different spaces, academia and so forth. And what, in terms of our multiracial democracy, do we want that these leaders to reflect the rich diversity that is in our country, or do we want it to be kind of the benefit and the exclusive rights of a select few that doesn't represent the breadth of our country? And so that is what's at stake. But also for those of us who listen to the argument, it's also about whether or not we what we are going to acknowledge about the realities of our world right now, because for the people who really oppose affirmative action, it's almost as if they live in a fantasy, as if, the world is equal, everyone has equal opportunity, colorblindness is the ideal. But when in fact, just 2 years ago, we had, as Damon had mentioned, we had this national reckoning, one of the largest social justice movements, in our life, not only in our lifetime, but in our history, acknowledging the very severe and persistent anti-Black racism that continues to pervade our society. And yet, 2 years later, here we are, at the Supreme Court, as if, the world is fine and that, racial equality has been achieved and so forth. And so, I think that is also at stake, because there's a larger conversation about how do we deal with racial inequality, especially in our educational system, which is so important and such a cornerstone of our democracy, and really affects what kind of country that we are right now and the type of country that we aspire to be.
Thanks, Jen. I know a certain justice who needed to hear that answer today. Kristen, let's turn to you. Why do these issues continue to require our attention?
Well, thank you so much for having me today. I am not a lawyer, but an activist, and actually a client of LDF's as an amicus in the Harvard case, and now a researcher looking into the kind of right-wing networks behind these attacks on affirmative action and the connections to so many other things. And so I'm just going to try to kind of pull together some threads that Damon and Jen have, laid out, and Gen Z as well. So, I mean, these cases came to the Supreme Court, and specifically to this Supreme Court, due to a decades-long right-wing backlash to racial and social progress, and specifically, I'd say, exacerbated or snowballing after the reckoning of 2020, after the murders of George Floyd and Breonna Taylor. And this backlash seeks to promote an undemocratic vision to dismantle our public institutions. And it's an insidious agenda that's soundly rejected by the clear majority of Americans. Setting up a battle and creating a media backlash against Harvard and UNC is already a victory for these forces in terms of undermining public confidence in academic institutions, facts, truth about race and racism for starters, but also about gender, climate science, voting rights, and more. And the right-wing think tanks and dark money funders behind eliminating affirmative action are the same ones behind Don't Say Racism, Don't Say Gay, Don't Say Trans laws across red state governments. The same forces are behind the gutting of Roe v. Wade and the right to reproductive justice. And we can't forget that Edward Bloom's stated goal has always been to end affirmative action everywhere. He's not stopping with higher education. His lawsuits, particularly Shelby County v. Holder, which Damon mentioned at the outset, which gutted the Voting Rights Act, really amount to a full-scale assault on racial equity. The voter suppression that we at the African American Policy Forum have been speaking out about on our recent cross-country From Freedom Writers to Freedom Readers Unbanned Books bus tour is something that we have been, trying to remind folks is deeply intertwined with the attacks on education, of which these on affirmative action are a part. Eliminating the consideration of race from college admissions, as Justice Ketanji Brown Jackson mentioned, could disproportionately censor students of color in their applications, which is akin to the censorship of all talk of white supremacy that's happening in these anti-CRT laws, and this effort to force LGBTQ people back into the shadow with Don't Say Gay legislation. And it's also related to labeling all kinds of discussions like these as divisive or profane. In fact, some of the anti-CRT legislation actually prohibits any critique of meritocracy, like Damon was alluding to earlier, because talking about the use of that term itself is considered divisive. And they're already coming for the next things. They're banning books about civil rights heroes, children's books about Martin Luther King and Ruby Bridges. They're declaring fetal personhood, launching legal attacks on race-neutral means of achieving diversity, even on diversity itself as a legitimate goal. And we saw in the arguments, a kind of almost outlandish discussion of diversity. But I think that and that similar focus on anti-Semitism are significant as an illustration of the role of the amicus briefs of the plaintiff side in this case, but also speaks to how it came before this particular Supreme Court, which obviously did not happen by accident, with the role of Mitch McConnell and this, the Federalist Society, et cetera. There's an excellent Yale Law Review article by Senator Sheldon Whitehouse, as well as a series of Senate reports on our captured courts, one of which looks specifically at the funding of Edward Bloom's lawsuits. And Whitehouse makes the point that the plaintiff funders are the same ones behind many of the organizations that submit amicus briefs, and the same who pour hundreds of millions of dollars into judicial nominations campaigns. And through this, their debunked theories and ridiculous claims about things like student affinity housing or the incredibly pernicious mismatch theories are given legitimacy when they're raised by the justices, as they were on Monday. With no funding disclosure requirements, these ties and the vast sums of money are obscured. And some of the organizations are actually listed as hate groups at by the Southern Poverty Law Center. But that doesn't seem to enter into the media coverage, which I hope is something we can talk about more later on today.
Yeah. As you can probably tell, Kristen has a mean presentation called Follow the Money, where she talks about this insidious dark web of dark money funding these attacks. Thank you, Kristen. So Nia-T, we'll turn to you now, and then Jinzi, feel free to hop in. From a civil rights standpoint, were there facts or information aired during oral argument that we have an obligation to amplify and or correct?
Yeah, I think we do. And I want to just step back for a minute. And I wanted to say that I feel like Justice Ketanji Brown Jackson really was the superstar of this oral argument. And she, towards the end of the UNC argument, left something that I've been thinking about, and I think that we need to amplify, right? Is that what are we valuing here, right? Under SSFA's regime, what would happen? Right, under petitioner's regime. And she gave an example of two equally qualified students applying to UNC. One is a white student who will explain to admissions officers that their family has been in North Carolina for 5 generations, that each generation has attended UNC, and they would like to continue this tradition. And under SFFA's worldview, under petitioner's worldview, this is value. They're going to get some sort of enhancement in their application, some sort of tip or something. The other student, also equally qualified, who's Black, will talk about how their family has lived in North Carolina for 5 generations, and not a single has been able to go and achieve higher education opportunities. And they would like to change that. They would like to be the first to do that. But that, of course, cannot be valued because it is based on race. And we are going to no longer value that applicant's history, their lived experiences, their heritage, potentially as a descendant of slavery, right? And so when we think about what were the facts that the petitioners brought forth in light of the questioning, they would like for us to not consider race at all as one of many factors. But more importantly, they went so far as to say a few things that I think are important to keep in mind from a civil rights perspective. One, they said that it cannot be considered at all, but not only, it can never be a compelling interest, which is really troubling. And anything that may serve as a proxy for race can never be considered. And that is troubling. And we're seeing that portion play out in the K through 12 context currently, where any awareness of racial disparity and any race neutral measures to correct them, like in TJ, there was a question about that, or in Montgomery County or New York or Boston, any awareness of that when taking race neutral measures, for example, like eliminating admissions fees for all students, are proxies for race. And that cannot be considered. And that will be anti-Asian because you are maintaining a status quo. You have to maintain the status quo where those in power stay in power, those with privilege maintain their privilege, and nobody else can. And I think that was really troubling. And I think we need to focus on that. And really, when we think about what are the repercussions of this worldview, if race was eliminated, we know that studies show that Latinx and Black students will fall precipitously. We know that according to at least one Georgetown study, for example, that the Asian admissions rates are really not going to have that much of an influence, maybe by 1%, maybe not. And white admissions will go up. So what when we eliminate race-conscious benefits, who is it benefiting? It's not benefiting Asian Americans. And in fact, in the Yale lawsuit by SFFA, they have decided that only some Asians are worthy of their protection, right? Whereas if you were a Southeast Asian, then you were not being discriminated against by these so-called policies that they object to, or who they purport to speak on behalf of Asian Americans. So it behooves us to question and to step back and look at what Justice Ketanji Brown Jackson advised us to do. Is like, what and why are we enacting these policies? What are we saying matters? And then to close out with Justice Kagan, who talked about the pipeline, about what do we want our communities? What do we value? Do we want doctors who look like the patients that they serve and can understand what their life experiences might have been? Do we want our government officials to be responsive to the citizens and their communities and the ones that they serve? These are all important. She went through a whole list of things, and our educational institutions are the pipelines for these. And so if we don't pay attention to that, if we disregard the importance of that, of having a diverse education setting, and race matters in that, to be clear, let's not shy away from that, then we can't also then expect these institutions to be reflective and responsive.
Goodness, I wish we had more time to dig in deeper. Hop in here, Jinsey.
Okay, that was fabulous. And I'm just going to pull out a couple more strands that I think it's imperative for our civil rights community to build upon. The first one that we heard on Monday was that California and Michigan and states that have banned affirmative action are so-called success stories, and nothing could be further from the truth. You can read the briefs from those states that were submitted to the Supreme Court, and they lay out in detail about what those precipitous drops were, in particularly in the Black and Latino community, and how that has translated to greater levels of isolation of students on campus. But there's also very sobering facts, and I'll share one, which is I'm from California, and prior to the affirmative action ban, the University of California's medical schools graduated a higher percentage of Black doctors than the national average. And after the ban, graduation percentages of Black doctors fell by more than 1/5 below the national average. And this has life and death consequences. There is research out there showing that having more Black doctors actually results in better health outcomes for communities of color. And so we have to take these drops seriously, and we have to demand better. We have to demand better both as civil rights advocates and as allies. The second thing from the argument that I want to pull out was brought up by David Hinojosa, representing our clients, and he made sure that the justices were aware of the history of these schools that have present day impacts. He said, we're talking about a flagship institution, UNC, that has excluded Black people for over 160 years, and that has current effects on the campus climate and the ability of Black and brown students to both access this highly resourced schools and to feel included and welcomed in that campus environment that still bears the names of Confederate soldiers and other white supremacists. And I think that really throws into relief too the absurdity of what we kept hearing about this 25-year limit that Grutter supposedly placed, which was completely aspirational and not actually part of the holding itself. But 25 years compared to over centuries upon centuries of racist exclusion, again, not acceptable. And it also draws out that we can't have some sort of blanket rule for all universities across the country, because the context of a Southern flagship may be different than different states. Mm-hmm. Lastly, I just want to throw in for this group that one of the things that I've seen coming out of the oral argument that I think we all have to be aware of is there's kind of a presumption about a bad outcome. And if you were in the courtroom, there was a very nuanced discussion, even from many of the conservative justices, about the facts and what the ultimate outcome will be. And it is imperative that we do not overread and overcorrect and strike fear into folks across the spectrum that race cannot be considered. When this decision comes down, we are going to have to read it very, very carefully and very narrowly. And we have to make sure that we do not scare people and chill people into reading more into it than what it actually says. It's true that the opponents are going to take it and they're going to try to bring more and more suits, but we as a community have to make sure that we push all educators to remain bold on diversity efforts.
That's right, Genzi. Thank you for that. Speaking of which, I have two questions here, and I'm going to go to Kristen first, and then to Jen. Feel free to answer either. So, continuing with the vein that Genzi was on, how can we combat the chilling effects and/or the overcorrection that Genzi was just speaking about that may occur from the SCOTUS decision? And then to you both, what should allies and partners and supporters and folks on this call be doing or thinking about between now and when the decision comes out? Kristen, let's go to you first.
Well, I think it's a really interesting question about the chilling effect. I think one of the things that we did see this past year, the past couple of years, when Harvard, for example, went test optional, it's been extended from the pandemic on, that there was actually, they saw a huge increase in the number of applications that they received. And I hope that we can try to kind of build on some of that to combat that chilling effect, because I think that's one of the really disturbing things that we saw in California, particularly at UC Berkeley, was that it just really gained the reputation of being a place that was not welcoming to Black students in particular. And I think we really, it's taken decades to try to combat that and to get anywhere close to, and we still have not gotten back to where we were before. I think one of the things that's related to this is that we just have to keep speaking up as much as we can about the role of the media in this. I was really disturbed in this kind of cycle that we're seeing with this, like the discussion of a diversity, to already see the New York Times have a debate on diversity with 2 of the 3 people being folks who had already expressed opinions numerous times on their opinion pages in favor of the plaintiffs in these cases. And so I feel like these debates in the media become opportunities for these kind of outlandish claims to be whitewashed back into the mainstream. And that's in the New York Times, let alone what's happening on Fox News and wherever else in the media. And when they're unfettered by fact checking, the examples that Genzi just gave, which are so compelling about the kind of medical profession, the brief from the medical schools in support of affirmative action, I feel like what more could we possibly need from that? The health outcomes for everyone are worse if we don't have more folks represented teaching each other cultural competency in medical schools across the country. And I think one other piece I just wanted to say about thinking about what we need to do is that the other side is practicing this sort of regressive intersectionality. They're funding organizations, from little tiny organizations to the biggest. They're very nimble and able to move people and individuals across issue areas. We saw that in the amicus briefs, where there are folks on the other side who have 2 briefs submitted because they've already created a spin-off organization that focuses on anti-CRT. And when you see the work that Edward Bloom, for example, has done with small conservative Asian American organizations, the relatively few that supported their side in that, there is just picture after picture of him visiting all of these organizations. And I think, and that particularly in that K through 12 context, so they're moving on into those areas. And so I feel like we have to make sure that we are speaking up for small organizations on our side, for parents at that local level, at the state level in particular, who want to get involved and bring together our fantastic grassroots organizations with our kind of like grass tops thought leaders. At one panel that I was on recently, a really young activist begged for two things. One was for people who are in less vulnerable groups to show up for targeted individuals when they are speaking out locally at school boards or and other places on a variety of issues. And the other was just for money. And I think he said, you wouldn't believe what we as like students can do with $200. And I think, you know, in my small grassroots organization where we're mostly just, you know, 5 volunteers working, you know, you can accomplish a lot, but giving support to those organizations means a tremendous amount. And I think that's something that we can all try to do going forward.
Small but mighty. Jen, let's turn to you. We're running low on time, so hop in, and then we're going to do a lightning round to close us out. What should we be
Sorry,
thinking?
I had problems unmuting myself. No, I think just really quickly, I just wanted to amplify what some of the things that Kristen said about the media. One of the very depressing and disappointing elements of the media right now is they've completely predetermined what the court's decision is going to be. And, you know, if we knew what the court's decision would be just by the makeup of the court and who appointed those particular justices, then you know, you have to question why even have a judicial process? Like, why even have lawyers argue before the court? You know, this is not a final decision. At the same time, you know, it is true that the court is very different now than it was, you know, 5 years ago, 10 years ago. But I think what we as a community need to do is to remain very firm and adamant about how important racial diversity, equity, and inclusion in education remains, and to really hold the court accountable as to what the, you know, what are the ramifications for a decision that would do so much tremendous harm to those principles, right? That we continue to believe that our educational system can be more equitable, can be reflective of the beautiful country that we live in and all of the wonderful diversity that you know that we have. And you know, and regardless of what the court does, and I guess this is something just to think about as well in preparation for whatever, like worst case scenario, best case scenario, we cannot give up at the ultimate goal, because, you know, in 1978, the Bakke decision was not considered a win. I think that many civil rights lawyers had wanted the court to go much further and allow more consideration of race in order to address, you know, real racial inequalities. And yet, you know, we took that decision and made tremendous advances in terms of opening the doors to, you know, elite universities like Harvard. And so regardless of what the court decides ultimately, and again, we shouldn't predetermine what that decision is going to be, we as a civil rights community still need to kind of press forward and try to create much more racial equality when it comes to, you know, not only our educational system, but, you know, throughout our society, but certainly our educational system, because it's such an important part of our society and people's opportunities in order to, you know, to be able to be a success and to reach their full potential.
Yeah. Thank you all. It seems like our work ahead includes a coordinated comm strategy to fight back, you know, the media is kind of taking over the messaging here. So we only have about 1 minute left. So Neeti, close us out here as an OG, as Damon called you earlier, affirmative action champion. Reflecting on the argument, are there any rays of hope or sources of inspiration to carry us forward?
I'm going to pick up a thread that I think all the panelists have raised, is like, let's not presuppose a decision. I think Gen Z is correct that this could be another Bakke where we're going to have multitude of opinions out there. We're going to have to parse through them very carefully to understand what it means. And the reason I say that is because what the oral argument showed was the justices, several of them, grappling with what does it mean and how to consider race. But in order for them, and when is it too much, like when does the pendulum shift? You know, there was a lot about that. But in order to have that conversation, the ray of hope is this, that in order to have that conversation, they are agreeing that race can be considered, that it is a compelling factor, that there is interest in educational diversity, and that there's room under the law to do so. And so I think that, if for no other reason, I think I was really encouraged to see that remains a possibility, as it should. We need more than that, as Jen said. That is just a very bare minimum. But I will take that as something to say I'm not yet throwing in the towel. And if I'm wrong about that, I'm still not throwing in the towel. That's not the issue. But nevertheless, that is something that I think that I really, it wasn't said explicitly, but I think it's important to say that what does that discussion really then leave us with? In order to have that discussion, you have to presuppose that race matters.
Amazing. Well, we will not give up in Nia T's words. This is not our first rodeo, in Damon's words earlier. So thank you so much to our powerhouse panel. Everybody's clapping for you at home. And you're getting a lot of love in the Q&A. So thank you all. Now, to turn to the next piece of our gathering today, we're going to do something really special. So for some background, as most of you probably know, in 2014, Students for Fair Admissions filed a lawsuit in the United States District Court for the Middle District of North Carolina. In 2017, the court granted the motion for the Lawyers Committee to intervene on behalf of students and alumni. Now, this status allowed the Lawyers Committee to uplift their stories and allowed the court to hear directly from students on the importance of race-conscious admissions and diverse campuses. These students were extremely courageous, extremely vulnerable, and undeniably powerful in sharing their experience through declarations and through testimony in court. And we would be remiss to not hear from at least one of them today. So here with us, a courageous, powerful student intervener, now an alum of the University of North Carolina at Chapel Hill, Star Wingate Bay is here with us. Star, thanks so much for joining.
Hi, thank you, Maya. Thanks so much for having me. And thanks to the Lawyers Committee. It's really an honor to be here. That panel was amazing. So it's so great to just sit here and listen to you all talk and school us. So thank you for letting me be here. I'm really excited.
That's right. Now it's your turn to school us. So let's unpack a little bit. How did it feel being back in the courtroom after so many years, being a part of these efforts to preserve affirmative action in higher ed?
It was wild. I joined this case while I was still in college. I graduated in 2016 and could not have imagined for myself that I would be down in DC for the oral arguments before the Supreme Court. It was really powerful to hear things that were mentioned in my testimony by the justices. I don't know how unique these things were to my experience. We, as all the student interveners, we all were on the same campus. But I mentioned the Confederate statues and the racist wallpaper and the buildings that are named after KKK members in my testimony. And so to hear some of the justice speak back to that, because it was in David Hinojosa's brief, was just really, really powerful.
Great. So we have a little bit of something for you to react to here today. So Justice Clarence Thomas went on said a speech about how he was not interested in the other pieces about belonging and the like. He was interested in what students came there to do, learn. So he said, I may be tone deaf, let's collectively giggle, when it comes to all these other things that happen on campus about feeling good and all that. I'm really interested in a simple thing. What benefits academically are there to your definition of diversity that you're asserting? And being one of the students who shared their story with the entire nation and signed their name on the dotted line, it seems only fitting that you would have an opportunity to respond. So what do you say to Justice Thomas and those with a similar question?
Yes, thank you for giving me this opportunity. This did stick out to me too, as one of his points. I think, first he says from his perspective as a Black man that he didn't go to racially diverse schools. And I think it kind of proves or disproves his point already that, you know, in my mind, race is not something you can separate from your experiences, and race colors and gives context to every application that comes through UNC or Harvard or any college campus's doors. But when I hear that, I'm like, how can you say that the environment in which you learn doesn't affect how you learn? You know, the circumstances in which you live and work, especially on a college campus where you are living most likely outside of your home for the first time as an 18-year-old to 21-year-old, affect everything you do. So there are certain things you have to take into the class with you. And I say that, you know, I think that students of color often have to be spokespeople in the classroom or come in with their guard up. And that's a burden that they shouldn't have to bear. And also, I think it kind of undermines, he says, you know, parents are sending their kids to school not to feel good. And I don't think that's the case. I think that people come to college to not only for educational benefits, but to grow as a leader, to grow socially. And that's how these colleges, which we have said earlier, Damon mentioned, I think that Andrew Brennan, one of the other clients, mentioned that campuses are incubators of democracy. So we need people, diverse dialogue and discourse happening in our humanities majors. And then you can't undermine the benefits that different perspectives, especially from racial difference perspective, come in innovation in technology and science and medicine. So to me, it's clear how diversity and different, you know, racial diversity on campus is essential to a good and a great, you know, education on campus.
I hope he plays back our webinar and hears your response.
Yes,
so,
listen to me.
Yeah, and you know, I think students agree with you. That's why we saw some powerful activism this week and, you know, in the previous years. So what stuck with you with some of that activism that you saw? And then finally, teach us here, how can the civil rights community continue to meaningfully amplify student voices and student stories in this fight to preserve affirmative action?
Of course, yeah. Oh my gosh, that was the best part. Seeing the student activists, the current university college students who were there was just amazing. That energy, like it was really powerful, really uplifting. I was talking to one who's a student who's a first year on Carolina's campus right now, and she was saying that she wasn't hearing enough about these affirmative action cases, especially given that UNC is involved in one. And so they started an affirmative action coalition on campus. And so I just think that that is just so powerful to me. And that is what campuses are for. This is these budding activists that, of course, we want to push out into the world to be our future leaders. And I think that is the key to amplifying and centering students' voices is universities. I would take that charge to universities, is to invest in these safe spaces and initiatives for students of color on campus to you know, to invest in them and to uplift them and their voices. And then for students, just to continue making our own voices heard. So much change that happens at the university level comes from students. And I would just encourage all students to continue fighting and making your voices heard. And for places like the Lawyers Committee, and thank you for taking on our stories and representing me as a client and as a student intervener and having my first person perspective of what it was like to be on a predominantly white campus and presenting that in front of the court. So just a big thank you.
Yeah. So I'm reminded in early October, we hosted a gathering for college and university students and alumni leaders from across the country, gearing up for activism in support of affirmative action. And in that gathering, a student leader reminded us that there is no movement unless people move. And we are all honored to have heard from you today, Star, a leader who moved, right? And still inspires all of us to move and keep going in this fight. So thank you so much for joining us and being a part of the conversation. Folks, let's clap for Star in your home, at your office. I know we're all thankful for her contributions to the conversation.
Thank you all so much for having me. This is so great, so fun. So I appreciate it.
Thanks, Star. So we're nearing the end of time. However, I would love to speak with you all about some of the work that we at the Lawyers Committee are doing to ensure that we are expanding access and equity for historically marginalized students. So if you would like, before I do that, because I know folks may have to hop off, if you would like to stay connected and stay updated about this work, we have a survey for you to fill out. All you're doing is putting in your contact information. That way we'll be able to send you email updates and let you know how you can get involved in the work. So Genzy, if you could drop that link in the chat, and if not, we will follow up with our thank you for joining with that link so that you can make sure that you sign up. So I want to now move to some of the work that we are doing to ensure that we keep equitable campuses, right? So I'm going to speak a little bit quickly because we want to respect your time, but we want to make sure we share with folks some of the things that we are doing. So you've been sitting in your chair in your office for a long time listening to us talk. So come with me, let's take a trip. Come with me to the campus of the University of Illinois at Urbana-Champaign. It is September 10th, and students, instead of waiting for fall and being excited about the new season, this crisp 3 a.m. morning, they are protesting their university. So this year is 1968. And the institution has implemented a program called the Special Education Opportunity, also known as Project 500. The initiative was originally designed to bring around 200 disadvantaged students to the state flagship. But after the assassination of Dr. King and growing unrest, leadership generously expanded the number to 500. So the 500 students were made promises around financial aid support, housing, and more. But when they arrived, the university dispensed lower amounts of loan money than originally promised, and even placed Project 500 students in small rooms and lounges, including some that were falling apart. So at 3 a.m. on September 10th, 248 students were swarmed by Champaign and Urbana and Illinois State Police and sheriff's deputies and arrested after an overnight demonstration in the student union. These students were advocating for the university to fulfill its commitments. So remember, this was Project 500. 500 students were brought to campus. So now come with me to the campus of the University of Illinois in 2019 and tell me what you think the number of, let's say, Black students admitted in the 2019 freshman class at that institution. The freshman class was 7,665. Out of that, 521 students were Black. In Ohio, Black students had similar struggles and developed a student newspaper and published demands. Now remember this, I don't just say this for anything, I'm coming back to it. Again, I'm going to be speaking quickly so we can get to it all. So let's move to the present day. With national coordinated attacks on education equity and with the affirmative action case at the Supreme Court's feet right now, it is our position that the civil rights community in particular can no longer play defense when it comes to racial equity, and that we must have other tools in tandem with litigation to ensure that institutions are more equitable. And so what the Lawyers Committee has done is pull together folks from higher ed institutions and communities and thought leaders and legislators and centering student voices, of course, to ensure equity in education. And so with that, I've just explained to you the Reason Project. So Reason is an initiative designed to center student and alumni and community voice in identifying targeted sustainable strategies to increase higher ed access and opportunity for students of color, and particularly for state flagships. Now, we've created multi-sector state-based coalitions in Illinois and Ohio to do this work. So when we say higher education, racial equity, what exactly do we mean? And this is where the reason framework comes in. We know that we don't just care about access. We don't just care about completion. We know that all of these things on the screen, recruitment practices, equity policy on campus, accountability, access to data, right? Social inclusion, our students feeling safe and comfortable to show up as their full selves on campus, opportunity culture and networks, pipelines, all of these things are important. So what does this work look like? So we began in the project in November of 2020 with the planning. And between then and February, we built the Reason Coalition, Illinois, and the Reason Coalition, Ohio. And so what each coalition has done is take a deep dive into understanding the challenges at these institutions. We developed student and alumni surveys. We held student focus groups called Campus Conversations. We hosted alumni focus groups. And we also retained a higher ed expert, Dr. Julie Park, who some of you may know, to conduct a full Reason, thus the acronym, Diversity, Equity, and Inclusion review of each campus. Dr. Park and her team reviewed her review served as a critical body of knowledge, aiding the coalition's capacity to better assess the racial equity initiatives of the universities and propose new solutions. So also each semester, the coalition onboarded a student advocate, a student leader that represents the student body on the coalition. And the student advocates also organized equity reviews and developed recommendations of their own, which is amazing. So what does this look like? All of this knowledge compiled to what you see on the screen, a set of racial equity recommendations to institutions on how to expand opportunity for students of color. Now, I put these on the screen and I told you about some of the student activism in the 60s and in the 70s on purpose, because the recommendations that the Reason Coalition proposed and the recommendations of the students at Illinois and Ohio in the 60s and 70s are eerily similar. The fight that we are fighting is not new. Now, for this project, we're not showing up to the institution and saying, hey, do better. We're showing up and saying, let's do a little better, and we want to work with you. So bear with me a moment with this analogy. I like to say, if the national affirmative action debate is the flood, projects like these, connecting communities to campuses to craft better outcomes, is the arc to get the next generation of capable and competent students of color through. Finally, if you'd like to learn more about our higher ed work at the Lawyers Committee, please go and visit our website, lawyerscommittee.org. So, just like the students, we are all here thinking about, strategizing for. I am a Pell eligible first generation college student from a city whose likeness was referred to as Poorville by a graduate school professor. Just like each of you, this work is personal. As such, I and our entire team at the Lawyers Committee, AAJC, LDF, and APF, we're deeply moved and heartened that a community such as this is lining up to carry the baton in this fight on behalf of bright, capable, deserving students of color from Poorvilles across the country. So we would like to send a resounding thank you for your commitment to a better higher education system and for joining us today. Again, if you're interested in staying plugged in, we will be sending that survey out. So thanks for joining, and we wish everybody a great afternoon. Bye-bye all. Thanks for joining us.
Thank you.